Welcome back to the Whiskey Politics Podcast on behalf of Ricochet.com, and we are still on the Weekly Standard Cruise, and I'm very delighted to have with us today Mr. Ken Starr. Ken, you were appointed by Ronald Reagan going back to 1983 for the U.S. Court of Appeals and Solicitor General of the United States from 1989 to 1993, and subsequently from 2010 to most recently, you were the President and Chancellor at Baylor University.
Right.
Yeah. Well, thank you for joining us.
My pleasure.
Appreciate your time. Well, first of all, let me first start with a little bit of ancient history. I'd love to discuss with you. You've argued 36, if I've read correctly, cases in front of the Supreme Court, going all the way back to your earlier days. And throughout that time, obviously, there's been a lot of political situations that have occurred. And for example, 1984, you were appointed as the independent counsel during the Clinton administration.
1994.
I'm sorry,
yeah.
1994.
Mm-hmm.
And obviously that was to look into the Whitewater investigation, which spread out into other areas, which included, obviously, the Vince Foster suicide and ultimately the Lewinsky scandal and the Paula Jones lawsuit. Real quickly, just out of the gate, in 2004, I believe you stated that you regretted having the Lewinsky situation presented on your plate. What did you mean by that?
It was a tragedy for the country. I wish it hadn't happened, but duty called, and it was the decision of the Attorney General, Janet Reno, that it had to be investigated because of the nature of the issues. Had perjury been committed? Was there obstruction of justice, intimidation of witnesses, and the like? But the country was dragged through a terrible ordeal, and I think it was just very bad for the country. I wish it could have just been handled very, very quickly, including just by truth-telling from the outset in the Paula Jones civil lawsuit itself, which gave rise to this entire chapter. It's an ugly chapter.
That actually led to the House voting for impeachment for President Clinton at the time. Obviously, he was acquitted in the Senate. And he continued on for what many people would consider a successful second term. But 20 plus years ago, and obviously in this most recent election, we had Hillary Clinton running. What impact do you believe that period, that chapter of our history may have had on the most recent election?
It's very hard to speculate. I think there was a question of trust. Is there trust in the chief executive? And that's pretty basic. And of course, she had issues with respect to the Whitewater arrangement back in Arkansas. But there was no indictment, no charges were ever brought against her. So I have a sense that with respect to the Secretary of State, Senator Clinton, it was, shall I say, very ancient history and didn't seem to play at all in the debate and the discussion. So I suppose more broadly just went more completely to the issue of, do we trust this person?
The acquittal of President Clinton, which was actually done by the Senate of the United States, that led to what a lot of people have had concern about over the past, let's say, 15, 20 years, and that is in relation to the rule of law, that some people are privileged while others are not. Do you believe that may have had a role in the most recent election as people's perception of different privilege?
Americans are very firm on the issue that the rules should apply to everyone, that you should not be the special character, you should not be the privileged character or the teacher's pet who can get away with stuff that nobody else in the class can get away with. And it's an issue for any government, but people want honest government, they want the rules to apply to everyone. And I think there is a sense, especially with respect to the controversy over the server, having the server at home, in Chappaqua, sort of what's going on here. This doesn't seem right. Some folks took it much more seriously than others, but especially with respect to national security, you need to protect the secrets of the country. So it's not simply abstract that the rule of law and the rules more generally should apply to everyone, but also maybe genuine harm was done to the nation's security.
So further to FBI Director Comey's decision not to indict and move the case forward, I think for many of us lay people that were watching him make that initial announcement back, I think, in July on television, the first 8 to 10 minutes, our mouths were open thinking he's about to prosecute or recommend an indictment. And then it was a turnaround. He used the word however. What was your feeling about that from your perspective?
I think it's a very tough judgment call. First of all, I have great empathy with prosecutors. He's obviously not the prosecutor in this case. It was a little odd for the FBI to say she's not going to be indicted. That's a prosecutorial decision. He's an investigator. He's the chief investigator. So, but leaving that sort of structural oddity aside, it was essentially the exercise of prosecutorial discretion. Sometimes you'd say, when did the prosecutor do that? When did he or she choose to prosecute, and so forth? But my own sense, it's only a sense, it's an inference, it's not based on any direct evidence. The director of the FBI did not want to interfere with an election. Here are the facts. Public, it's up to you. You decide. I'm not going to be the person who essentially decides the presidential election. Now, there are those who said in light of his handling of it, it had a clear and present effect. How do you know that? It's all questionable, etc. But I think he decided this is now up to the people. I've done my duty,
right,
which is I made a commitment to Congress that here are the facts as I understand them. Oops, now here are new facts. I have a duty to examine them. To be honest, I was sympathetic with his situation.
Okay. I want to move on to a couple of other issues here. With FBI Director Comey saying that let's leave it up to the people. Another decision was made in recent years, and that was on the Supreme Court, and that had to do with the Obamacare, the Affordable Care Act, and Justice Roberts basically reverting back to calling it a tax. A lot of people, especially conservatives, were extremely surprised. Some would say that that is similar to what FBI Director Comey did by basically saying that I don't want to have a part of this decision. Is that something you would agree with or disagree with?
I was very sympathetic with the Chief Justice. I know there was a huge reaction, very negative. Who appointed this person? Senator Cruz suggested that he regretted his vote. I think that's an overreaction. What I believe was going on is that the Chief Justice of the United States was seeking not to interfere with the will of the people. That's what elections are all about. Elections have consequences. And there was no suggestion that Obamacare, for all of its faults, somehow infringed on individual liberties to speak and engage in the marketplace of ideas. I think that's John Roberts. That is, I will be very aggressive as a judge in protecting the free flow of ideas. But once the democratic process works, you're going to have to really convince me, almost beyond a reasonable doubt, that this law cannot stand when it's a regulation of the economy. Not everybody's going to agree with that. Many people will disagree with that. But it's very rooted in American constitutional tradition. We're here to protect the democratic process and not to second-guess the results of the democratic process.
So you believe the will of the people takes precedent over constitutional law or what the intention of that law is?
No, I think he interpreted the Constitution of the United States and the structure of the Constitution as requiring judges who are unelected and unaccountable to the people to, as it were, bend over backwards to try to stay out of the process of legislation.
Okay.
Leave it up to the people. And you see what happened. If let's just assume that the law had been declared unconstitutional by a 5-4 vote, that would have created an enormous backlash. It would have put the Supreme Court in the midst of this firestorm. I think it would have been further polarizing to the American and for the American people. Now you say, well, those are just prudential considerations. Principle governs. One of his principles is let's preserve the democratic process. Let's bend over backwards. And so was I persuaded by his analysis that it's a tax? I was not. Did I believe that it was a colorable claim that passed what we call the red face test? Yes, I do. You can disagree with it. But I think what was underlying it was the idea that we do not want judges running the country.
Now, if he didn't believe he was the swing voter, do you think he would have voted differently on that?
I can't say that, but I think he takes the protection of the court as an institutional government very seriously. He has a great sense of history. Not only was he a history major, but if you're around John Roberts, he is a polymath. He has many different interests. but he is very rooted and steeped in the history, not just of the court, but of the country. And he sees in John Marshall and the other great Chief Justices examples of, let's take care of this court, let's take care of the country.
Mm-hmm. Further to concerns about the Supreme Court, obviously and I believe, if I remember correctly, a friend of yours, Nina, Antonin Scalia, Justice Scalia, obviously passed away, a tremendous loss, especially to conservatives in the United States, and also to the Supreme Court as a whole. Constitutional justice. We're taking a look at an aging Supreme Court right now.
Yes.
Okay. I don't know how Justice Alito is doing. Justice Thomas is getting up there in years.
They're the youngsters.
They're the youngsters, right? And obviously, there's a couple of liberals that lean liberal anyway that are obviously getting in age. Did the election of Donald Trump make you more confident, or are you more concerned about the future of the Supreme Court at this stage?
Oh, I feel so much better about the Supreme Court. First, we have the vacancy, the tragic death and the unexpected death of Justice Scalia. So there's a vacancy right now, which the president-elect will fill. The 21 names on his list are great. They're all great. So choose one of those persons. I don't know of anyone who was deemed by serious people as somehow less than completely qualified to go on the court. So there's a very deep bench for a Republican president to draw from the federal courts of appeals and so forth. And I believe literally everyone on that list, if memory serves, has serious and substantial judicial service. So you've got a record to go on and so forth. So I think that whoever this initial nominee is will, first of all, fill a very important vacancy. Mm-hmm. And secondly, you're quite right. They're justices in their 80s. It would not be surprising for Justice Kennedy, who next year will celebrate his 30th anniversary on the Supreme Court, and he was a judge on the U.S. Court of Appeals for the Ninth Circuit before that, to say, it's time for me to step down as well. No one knows, but that would be reasonable expectation. So
you're very comfortable that President-elect Trump will be electing constitutional conservatives?
Oh, yes, given the 21 names. Now, if he had not come forward with that list, it would be a question mark, right? We have no idea of what, in his heart of hearts, the president-elect thinks about these things. He doesn't give speeches about them. He's not a lawyer. We don't appreciate what he said about one of the federal judges involved in his own litigation, which is unfortunate. But more generally, who will he appoint? He showed great seriousness of purpose in saying these 21 people are people who are qualified to go on the Supreme Court. And that should make the American people as a whole, but certainly those who love the traditions of the Supreme Court, let's call them conservatives and traditionalists, should feel extremely comfortable and confident going forward.
There's going to obviously be a lot of cases over the next several years that are going to be brought to the Supreme Court. And as I mentioned on the outset, I think you've spoken in front of the Supreme Court some 36 times. Is that correct?
Right.
I mean, that's incredible. So somebody with your perspective, you've seen a lot of different types of cases, some brought by conservatives, and you've had some unlikely alliances. I believe you actually worked with the NRA and the ACLU against the McCain-Feingold Act of free speech.
Yeah. We had a great coalition that was a complete free speech coalition. The ACLU has since had second thoughts on the whole area of campaign finance, but a number of us viewed, and I still do, that this is speech, and the more speech, the better.
Mm-hmm. So is there a concern right now, Chancellor, Baylor University, President of Baylor University, is there a concern right now in 2016, 2017 that free speech is under attack, especially on college campuses and our culture as a whole?
Yes, there is a very clear danger, and I hope that university leaders and that the culture more generally will just speak out and tell these young people, grow up. Welcome to the land of freedom of speech. But we really have lost something over this last generation. That is a commitment to what the Supreme Court, the Warren Court, the liberal Warren Court, called our commitment to our system of free expression, with very few exceptions. The law of defamation, the so-called fighting words, you can't get in someone's face and insult them and perhaps cause of fisticuffs and the like. But with very rare exceptions and very limited exceptions, our commitment is to a system of free expression. The students at so many college campuses have lost that, and I think there's an undue coddling of these students. And the best expression I've seen recently is from the University of Chicago, which that statement of commitment to academic freedom and academic discourse is something that every college president should keep in his or her mind pocket vest and just pull it out. If some student or parent says we need safe space and so forth, the response is welcome to democracy.
Obviously, a lot of people are saying that this is starting to take place across a wider swath of higher education, and that it has been, as you've used the word, coddled college kids and university kids in those safe spaces. But isn't that up to the professors and the leaders of those universities all across the board? I suppose my question is, as a president, and up until most recently you were just one for the last 6 years, what impact could you personally have on those individual professors and leaders at those universities that may have political differences than you?
I think doing what the University of Chicago did, here is a statement of our position, which is essentially a declaration of freedom. So it needs to come from the top. And then if there are issues that arise, then the president, whoever the CEO is, should meet with the faculty senate. They're the duly elected representatives of the full faculty at virtually every college and university, certainly one of any size, and say, I'm committed to the idea of freedom of speech, freedom of expression, and that's bedrock in a democratic society, and especially in the United States, where we have a written First Amendment with the great traditions of freedom of speech that need to be taught and entrusted now to the rising generation. There has been, I think, a profound failure to accomplish that educational goal.
Interesting. On another issue, one of the things that continually bubbles up at the Supreme Court, and especially on a state level, is something that you've been involved with, and I think that was in Virginia, and that's regarding the death penalty.
Yes.
You fought against it? I believe you brought a case to you were fighting to have
It was clemency.
It was clemency.
Yeah, it was to have the sentence reduced from death to life without possibility of parole.
Do you believe the death penalty is a policy or a procedure whose time has come and gone?
No. I'm not an abolitionist, but I do think that there has to be great attention paid to the use of the death penalty. I think Congress has set, and the Justice Department has set, a really good example of having a careful review process before any of the 93 federal prosecutors, 93 United States attorneys, can seek the death penalty. We don't have that in, I believe, any of the states. So there's so much discretion entrusted to an individual elected district attorney. Mm-hmm. And so in California, for example, when I was dean of the Pepperdine Law School, I was struck by the fact that some counties were death counties and other counties were not. That the duly elected DA, even though the death penalty was on the books in the entire state of California, would never seek it.
Right.
I was troubled by that as a practical matter, as a moral matter, and certainly as a matter of public policy. So I recommended that there be some kind of review process, whether it's in the governor's office or the attorney general's process. It's going to be a political process in the sense of the elected representative of the people, but instead of having so much discretion entrusted to locally elected officials.
Yet the state Supreme Court of the state of California has allowed a lot of those cases to remain on indefinitely, and I think it's one of the longest periods for people to remain on death row. Yes. San Quentin. I mean, it's just they're never going through. So, does it even have an impact? Does it deter anybody anymore? I mean, that's a lot of.
We don't know,
okay.
But I do know this. There are times when we saw this with the recent decision to seek the death penalty in the Charleston church case, that I believe it's appropriate for society to say this crime is so heinous and so horrible that this merits the death penalty.
Right.
I'm not there yet in terms of abolitionism, but I greatly respect. And states seem to be moving more in the direction of abolition. But in the age of terror, I think at this stage of our history as a free people, that the death penalty is appropriate when reserved for the most serious kinds of cases.
Okay. A couple more questions. One for you in regards to, I recently saw you on, of all stations, ESPN. You reported on the chancellor's, as president and chancellor at Bain University, and there was a rape situation that occurred. And without getting into details on that, we're seeing a lot of these situations that are bubbling up around the country, University of Virginia and the Rolling Stone article and other places as well. Do you have a concern that there is a much more of a concerted effort to listen to whatever accusations that are occurring without substantive proof in those situations, especially when it comes to rape or other assaults?
It's a growing issue, and thank you for saying off campus. The Office of Civil Rights of the Department of Education, the Obama administration, I believe, expanded way beyond what one would expect under the law, under the literal language of Title IX, that somehow the university is responsible for what happens off campus at a non-university sponsored event. It just doesn't seem quite right. And then when you go back to the original guidance of the Office of Civil Rights, you see, well, there does have to be some sort of, as it were, infection of what happened off campus, on campus. I don't think that's being explored carefully in the whole Title IX sexual violence adjudication process. I think it's time for a close and careful look at that around the country. I hope that the new Secretary of Education will, at some point, she has great responsibility for all of education in the United States in terms of the reach of the federal government, for better or for worse. But this is an area she needs a director of the Office of Civil Rights who will be, I think, faithful to the law, as opposed to there's a social ill out there and Washington has the responsibility for it. Now, that having been said, we do need to address the cultural issue of the excessive use of alcohol and then the cultural, shall I say, bacchanalial situation that seems to exist throughout the country.
Mm-hmm. And that is something which you believe shouldn't be answered by a centralized government in Washington, but more on a local?
Yes, exactly. If there was an act of sexual violence, how can a college seek to adjudicate that? Where are the witnesses and who is qualified to do that? And by definition, an act of sexual violence is a crime against the state. It's a terrible offense against the victim. Mm-hmm. And so the victim needs to go to say if that victim, the complainant in Title IX jargon, feels as if a wrong has been done, then there are avenues of redress. You go to the law enforcement, as opposed to trying to turn colleges and administrators in universities into courthouses. Mm-hmm. It's not working. And
where did the controversy come down with that? Because obviously that's a law-minded answer, and it sounds like common sense to me. Why was there a controversy over this?
It was generated by virtue of a study that suggested that 1 out of 5 young women on college campuses in America are victims at some point during their collegiate career of an act of sexual violence. Now,
that study, by the way, has been invalidated on multiple different fronts.
It certainly has been criticized, but I think that's what got it started. Okay. And then certain United States senators took up the cause. Then the key, though, was the Department of Education and the Obama administration and the Office of Civil Rights making this one of their very important areas of priority. So it actually launched with a letter, a Dear Colleague letter to all university presidents on April 4, 2011. Then the adjudicatory process was, as it were, moved onto campus, and we've now had these 5 years of experience with adjudicating these claims of sexual violence, and it's now resulting in litigation by those who have been convicted in the process, saying I was not treated fairly, due process rights were not honored and so forth. And so my answer is, let's move that back to where it belongs, namely in the arena of law enforcement.
Fantastic. Well, one last question for you. Obviously, we are right now in the stage between the election and the inauguration, and the cabinet picks are happening on a daily basis. Senator Jeff Sessions, you and our discussion today have revolved around rule of law. What is your opinion of Senator Sessions, and do you believe that he will be approved? And what kind of Attorney General will he serve?
Yes, I have very high regard for Senator Sessions. I've known him since his days as United States Attorney in the Southern District of Alabama. Mm-hmm. He's a very able, thoughtful person, and happily the President-elect has complete confidence in him. And so that means that when the Attorney General sits down with the President and says, this is the rule of law, this is what can be done and cannot be done, I think that confidence is going to be there. And Jeff Sessions is a man of great courage. So I think he's going to be confirmed overwhelmingly, and will do a great job.
Do you think these drummed-up controversies from 30 years ago are overstated, in fact, even factually correct?
That I don't know. I haven't done, but first of all, Jeff Sessions is a very honorable man of goodwill.
Good. Well, greatly appreciate you taking the time. If you'd like to learn further about Ken Starr, you have a wonderful book out there. I believe it's First Among Equals, and it's in regards to the Supreme Court in the United States, and it's a fascinating read. Greatly appreciate your time, and have a wonderful rest of the trip.
Thank you.
Thank you very much.
Thank you.